Opposition. Opposition refers to a process by which a patent application or a granted patent can be opposed on specified grounds. And the consequence of an opposition is, if successful, it would lead to the rejection of the application or it would lead to the revocation of the granted patent. Now, these consequences are different. In the case of an application, because the application is still under consideration and no rights have crystallized with regard to that application, if an application is opposed successfully, it results in the rejection of the application. The application is rejected. Whereas when a patent that is granted is opposed, there are already rights that a person can exercise with regard to a granted patent. We saw that the rights under section 48, which gives a patentee, the right holder, the right to stop others from making, selling, offering for sale, importing, and using, can be exercised with regard to a granted patent. So when a granted patent is successfully opposed, we would say that the patent was revoked based on an opposition. So this distinction is something which we need to bear in mind. An application that is opposed successfully would lead to the rejection of the application, and a patent that is opposed successfully would result in the revocation of the patent. The patent will now be revoked from the records. So opposition can happen either with regard to a granted patent or an application, patent application. In both cases, the patent or the application is challenged, and the opposition happens only before the patent office. There are other procedures like a revocation, which can happen before the Intellectual Property Appellate Board, a body which takes appeals from the patent office, or there are invalidity proceedings, say in the form of a counterclaim, which can be raised before the High Court in an infringement suit. So that would again result in the revocation of a granted patent. So the opposition procedure is different because the opposition procedure happens at the patent office. There are some distinct advantages here. Because the opposition happens at the patent office, and because the patent office is the body that grants patent rights, it is easier to take technical arguments and to prove technical grounds for opposing a patent or for challenging a patent. Whereas the Intellectual Property Appellate Board or the High Court, though they may have the assistance of a technical member or they may be able to get scientific advisors to advise them, it is not the same as the granting body. The patent office being the granting body, the ability to appreciate technical arguments and to look into records pertaining to the patent are more comprehensive than the appellate bodies like the Intellectual Property Appellate Board or the High Court. Opposition proceedings are important because they offer the first chance to raise a challenge for a patent. Because it happens at the patent office, a pre-grant opposition or an opposition before the grant can be instituted effectively in such a way that the opposition can stall the grant of the patent itself. Now, this is critical when an unjustified patent is about to be granted. In instances where a person needs to quickly challenge a pending application, the patent office offers opposition proceedings for doing that. Countries normally have post-grant opposition, but India is an exception which has both post-grant as well as pre-grant opposition. So we have a mechanism by which an application can be opposed. As we have mentioned, there are two types of oppositions, and the oppositions are under different provisions. The opposition before the grant is also referred to as pre-grant opposition, and the opposition after the grant is also referred to as post-grant opposition. Now, let's look at pre-grant opposition or opposition before the grant. Now, the nature of the pre-grant opposition is distinct and different from a post-grant opposition. We will find that the proceedings are summary in nature, summary as in very brief compared to a post-grant procedure, and a pre-grant opposition is not regarded as an inter partes proceeding. Now, inter partes is a legal terminology which is used when two parties are fighting or pitted against each other. Opposition is not a proceeding which is inter partes, though a third party intervenes into the patent office. An opposition is triggered by a third party. The Act says any person can file an opposition. Though it is triggered by a third party, the third party merely supplies information as to why a patent should not be granted. And the third party, or whom we call a pre-grant opponent, raises objections with the evidence showing why a patent should not be granted. Now, the proceeding is largely between the applicant and the patent office. The third party does the job of an friend of the court, amicus curiae. He assists the patent office. So he's a friend of the patent office. He assists the patent office, or the courts have used the language, he aids the examination. So he helps the examination of the patent. So in that sense, a pre-grant opponent is not regarded as a party, and hence pre-grant opposition or opposition before the grant is not regarded as inter partes proceedings. That also brings some detail on the status of the opponent. An opponent is a person who can make a representation, but he does not have rights of a party. For instance, the opponent, if he fails in the pre-grant opposition, does not have a right to appeal. An opponent who fails in the pre-grant opposition after the patent is granted may file a post-grant opposition. That's possible. But an opponent does not have the right to appeal. Now, the right to appeal is normally given to a party. If you litigate in the district court and you are the defendant in a suit and you are not successful in the suit, you have a right to appeal to the High Court. Now, this is an inherent way by which we understand whether somebody is a party to the proceeding. The pre-grant opponent does not have this right to appeal. So we cannot consider the pre-grant opponent as a party to the proceeding. The procedure for pre-grant opposition is stipulated in Rule 55. A written representation has to be submitted. There is a particular form for it now. And the procedure is a time-bound procedure. The procedure largely moves in this pattern. The pre-grant opponent files his objections along with the evidence. The copy of the opposition along with the evidence is sent to the applicant. The applicant gives his response on the opposition, and then there is a hearing. The hearing occurs before the controller. The controller can call the applicant. The controller can also call the opponent if the opponent insists on a hearing. The law states that a hearing is not automatic. A person has to request for a hearing. So if the opponent has requested for a hearing, then the controller will hear the person and then follow it up with a written order. So there is a written procedure. So there is a written representation followed by a response by the applicant, and both the written representation and the response will have its evidence. There is a hearing, and the hearing is followed by a written order. Now, all these things happen in a time bound fashion, and for this reason, we regard pre-grant opposition as a time bound proceeding. When we compare opposition after the grant, we find that the post-grant opposition is between two parties, what we can call an inter partes proceeding. Party 1 being the patentee, against whose patent the opponent files an opposition. Now, they have party status because regardless of who succeeds, the other party can take up the matter in appeal. That's one way for us to understand whether they have party status. Now, one distinguishing feature between the pre-grant and the post-grant is that the post-grant opposition has to be by a person interested, and a person interested is defined under the Act as a person who has a research interest. It includes a person with a research interest. Now, pre-grant opposition, on the other hand, can be filed by any person. So this is a difference between pre-grant and post-grant opposition. Now, this would require a person to have some technical competence in the field. So that is why a person interested is defined as a person having a research interest in the Act. The procedure is also different from pre-grant opposition. The opponent has to file a notice of opposition. There is a form for that. And after the notice of opposition is filed and the reply is received from the patentee, an opposition board is constituted. Now, there is no opposition board in pre-grant opposition. Now, the opposition board comprises of 3 examiners who have not dealt with the patent before. So this is more like an additional review by a different set of examiners. The opposition board submits its report. The report is not binding on the controller. The controller is the person who sits and adjudicates the opposition. The controller listens to the parties. There will be a hearing, and there will be prior notice of the hearing, and upon the hearing the controller will decide whether to revoke the patent if there are grounds for revocation, or whether to amend the patent if the objections are of such a nature that they can be amended, or whether to allow the patent to continue, which means whether to reject the opposition. So the consequences of a pre-grant opposition are either the patent gets granted or the patent application gets rejected, whereas a post-grant opposition, there could be 3 consequences. The patent may get revoked, the patent may get amended, or the patent may be allowed to continue. Now let's look at the grounds of opposition. The grounds of opposition are common for both pre-grant and post-grant opposition. The only difference is that the stage in which the grounds are introduced. In a pre-grant, as the word stands, the opposition grounds are introduced before the grant of the patent. And in a post-grant, they are introduced after the patent is granted. Though these proceedings happen in different points in time, the grounds remain the same. The post-grant opposition can be filed 1 year after the patent is granted. So there is a timeline for filing the post-grant, whereas a pre-grant opposition can be filed any time after the patent is published but before the grant of the patent. There are 11 grounds, and the grounds are meant to be exhaustive, meaning which you cannot add new grounds of opposition which are not covered in the 11 grounds. For instance, a patent cannot be opposed for lack of unity. Unity is a feature that each application should only cover one invention if there are more than one invention, it is not a ground for opposition. When an invention is wrongfully obtained, that can be a ground for revocation. Now, the ground for revocation in pre-grant is mentioned in 25.1 and the same ground is mentioned in 25.2. Now, this ground has the focus on the identity of the invention. If an invention is claimed by a person, but it was wrongfully obtained by that person and a application was filed, the person from whom it was wrongfully obtained can file an action, an opposition, to oppose the patent, and as a relief, the patent can also be changed to the name of the opponent. So, because the claim here is that the patent was wrongfully obtained, the person who was the rightful owner can also request the patent to be amended in that person's name. Now, the relief may vary if the person is not interested in having a patent in their name, in which case they will ask for a revocation. Prior publication, that's another ground on which a patent can be opposed. There are two kinds of prior publication. One is published in India before 1st Jan 1912, that is with regard to a patent application, or published in India or elsewhere in any other document. So this covers two kinds of publications. It covers patents and it covers non-patent documents. Prior publication is an objection of lack of novelty. If the information that is covered in a patent is published before the date of filing the application, then it can be a ground for revocation. If the published information is in a patent, there is a provision for that. If the published information is covered in a non-patent literature, then that could also be a ground for opposition. Now, there are certain statutory exceptions. Matter published earlier but published without the consent will be excluded. The next ground of opposition is prior claiming. Again, this is a ground which pertains to lack of novelty. Now, this is a ground where the anticipation happens by another application, where the application is published in India with an earlier priority date. Now, one of the things you could ask in this ground is for the controller to require an amendment or an insertion of the reference of the earlier claim. So, reference could be one of the recourse that a person asks. Again, a patent cannot be granted if that invention is claimed earlier. Prior claiming refers to a claim made earlier in another patent application. Prior knowledge or public use is another ground. This is again a ground which comes under lack of novelty. So, if there is prior knowledge or public use of an invention, then that could be a ground for challenging an application. A patent application can be challenged on the ground that there was prior knowledge or the invention was used publicly. Lack of inventive step is one of the strongest grounds on which any patent can be opposed. So this again can be used either before grant or after grant, and the provisions are different. Now, inventive step pertains to what is not obvious to a person skilled in the art. The invention should involve an inventive step. An inventive step is defined as an aspect of the invention which is not obvious to a person skilled in the art. Another ground for opposition is the fact that the subject matter of the claim is not an invention or it is not patentable. Now, these are exceptions to patentability covered under Section 3 and Section 4 of the Patents Act. Now, exceptions to patentability, we have covered this. It's a long list of things that cannot be granted a patent. Atomic energy inventions cannot be granted a patent under Section 4. So, if you need to oppose a pending application or a granted patent, citing one of those provisions under Section 3 or under Section 4, then these are the grounds that you will use: Section 25(1)(f) or Section 25(2)(f). Insufficiency is also a ground for opposition. Now, there is a requirement under the law that the patent specification shall sufficiently and clearly describe the invention. Description of the invention is a requirement for the grant of a patent. If the patent does not clearly describe the invention, then the patentee has not performed his part of the bargain. But the grant of a patent is a bargain where, in lieu of the disclosure that the patentee makes, the law affords him a 20-year exclusive right over his invention. So, if the description is not clear or it is not sufficient to enable a person skilled in the art to make the invention, that can be a ground for revocation. So, this is an internal ground. The description of the invention in the complete specification has to be of such a nature that it can allow others skilled in the art to come up with the invention. So, the method of performing should be clear and distinct. Another ground for revocation is non-disclosure of information. There are certain information that the patent office requires from the applicant. If the applicant does not disclose that information or does not keep the patent office informed with regard to that information, that can be a ground for opposition. Now, Section 8 of the Patents Act requires an applicant to keep the patent office informed of applications that the person has filed in other patent offices, which are similar to the application filed in the Indian Patent Office. This requirement is more of a nature to keep the patent office informed of what is happening in other patent offices. For instance, if an application is filed in India and similar applications for the same invention are filed in Japan, China, and the United States, and if Japan and the United States rejects the application for whatever reason, then the Indian Patent Office would like to know that those applications were rejected, and it casts a duty on the applicant to inform the patent office about those rejections. So here is an obligation casted on the applicant to keep the Indian Patent Office informed as to what is happening in other patent offices pertaining to the same invention. So non-disclosure of information is a ground for challenging a patent. Another ground for challenging a patent under opposition is when a person claims or falsely claims convention priority. Now, convention priority is the 12-month period within which, after you file a basic application in a convention country, you can enter any convention country within 12 months. So there is a timeline wherein you can claim the convention priority. Now, if the convention priority is falsely claimed, meaning which, one, you file an application in a convention country, but you do not enter within the 12 months in the other convention country, so you have not kept the 12-month period, you have not entered within the 12-month period, or you seek priority from a country which is not a convention country. So this refers to a false claim to convention priority. So it covers time-barred convention applications, and it also covers situation where the basic application is not a convention application. Non-disclosure of biological material is again a ground for opposition. An applicant who uses a biological material is duty bound to disclose the biological material. If that is not done, it can be a ground for opposing a patent. And finally, anticipation by traditional knowledge. If something is within the knowledge of local or indigenous community, and it can be proved by oral or documentary evidence, then that can be a ground for objecting a patent. A patent can be opposed if the invention is known or anticipated by traditional knowledge.